plaintiff cannot recover any damages in this case if at the time of the accident her husband was himself negligent. That is, if he failed to exercise reasonable care for his own safety, such care as men of ordinary and reasonable prudence usually exercise under the same or similar circumstances, and if such negligence was a substantial factor or a material element in causing the accident. The first question that you will take up and determine when you retire to the jury room is whether the defendant, the City of Rogers, was negligent in the manner and as claimed by the plaintiff. If you fail to find from the preponderance of the evidence, that is, by the greater weight of the evidence, that it was negligent in the respect claimed, then you need consider this case no further. But if you find that the City of Rogers was in fact negligent, then you will consider whether or not such negligence was the proximate cause of the accident. The burden of proof rests upon the plaintiff to prove by the greater weight of the evidence that the City of Rogers was negligent and that its negligence was the cause of the accident in question. If on this question of the negligence you will find the evidence evenly balanced or preponderating in favor of the defendant, then you will find a verdict of no cause of action. The burden of proof rests upon the defendant to prove by the greater weight of the evidence that the husband of the plaintiff was negligent and that his negligence proximately caused or contributed to cause the accident in question. If on this question of his negligence you find that the evidence evenly balanced or preponderating in favor of plaintiff's favor, then you will find that the plaintiff's husband was not negligent. If you find under the rules given you that the City of Rogers was negligent and that its negligence proximately caused the accident in question, and you find that the plaintiff's husband was not negligent of any guilt, then your verdict will be for the plaintiff for the damages which you find that the plaintiff has sustained. On the other hand, if you find under the rules given you that the accident was caused by the sole negligence of plaintiff's husband and that the defendant was not guilty of negligence which caused the accident, or if you find that both the plaintiff's decedent and the defendant were negligent and the negligence of both of them proximately contributed to cause the accident, then the plaintiff cannot recover in this case, and you will find a verdict of no cause of action. If you find a verdict for the plaintiff, then the next question is the amount of damages to be awarded. The damages to be awarded are solely by way of compensation for pecuniary loss suffered by the widow and her children. You can allow no damages for the pain and suffering for the deceased, nor can you allow any damages for the grief or mental pain or suffering of the widow and the children. The test is what, in view of all the facts shown by the evidence, was the probable pecuniary interest of the beneficiaries in the continuance of the life of the decedent. A proper estimate may be arrived at by taking into account the occupation of the deceased and the salary or income therefrom, his health, age, probable duration of life, talents, habits of industry, success in life in the past, and the amount of aid in money or services which he was accustomed to furnish his family, all as found from the evidence in this case. The surviving widow and minor children had a legal claim upon the deceased for their support, and it is presumed that they suffered some pecuniary loss, but the amount of such loss is for the jury to determine in this case. In this case, there being no proof of any damages such as funeral expenses, doctor bills, and expenses caused by the death, they are not in the case, and you cannot allow anything for them. You will take into consideration all the facts found by you from the evidence in the case. It is for you to determine from the facts in the case as you find them what the pecuniary loss was, and you will determine and decide what the amount of damage is if you find that the plaintiff is entitled to recover. The fact that Felix J. Schroeder left a widow and children dependent upon him recommends itself strongly to sympathy, but you are instructed in determining the issue in this case that you are not to be controlled or guided in any degree by any sympathy, bias, or prejudice toward the plaintiff or toward anybody, but you must determine this case wholly and solely on the evidence and determine therefrom and without any sympathy, bias, or prejudice the issues of negligence and contributory negligence which have been submitted to you.